Law of tort. Remoteness of damage. In negligence claims, once the claimant has established that the defendant owes them a duty of care and is in breach of that duty, which has caused damage, they must also demonstrate that the damage was not too remote. Remoteness of damage also applies to claims under the Occupiers' Liability Acts and to claims in nuisance. Originally, a defendant was liable for all losses which were a direct consequence of the defendant's breach of duty. This was seen in Remoteness and Furnace Withy, where the stevedore was liable when he dropped a plank of wood into the hold of a ship. The plank struck the ship, causing a spark which ignited gases which had built up. The stevedore was liable despite the fact that such an explosion was an unforeseeable consequence of dropping wood. This was largely considered unfair, as a defendant could be liable for damage which was not foreseeable and therefore, they could not take steps to prevent it. The direct consequence test was overruled in the Wagon Mound No. 1. The Privy Council replaced it with a new test for deciding if damages are too remote. In the Wagon Mound No. 1, the defendant's vessel, the Wagon Mound, leaked furnace oil at a wharf in Sydney Harbour. Some cotton debris became embroiled in the oil and sparks from some welding works ignited the oil. The fire spread rapidly, causing destruction of some boats and the wharf. The Privy Council held that Remoteness should no longer be regarded as good law. The new test for remoteness is whether the damage was of a kind that was foreseeable. The kind of damage that was foreseeable from an oil leak was environmental damage, not destruction by fire of the kind experienced by the claimants. Therefore, the damage was too remote and the defendant was not liable. An important principle from this is if a foreseeable type of damage is present, the defendant is liable for the full extent of the damage, no matter whether the extent of damage was foreseeable. The Wagon Mound test was considered and applied in Doughty v. Turner Manufacturing Company. An asbestos lid was accidentally knocked into a cauldron of molten liquid. A few moments later, an explosion occurred. The court held that the damage was too remote. Whilst it may be foreseeable the lid may have caused a splash resulting in a scald, it was not foreseeable that an explosion would occur resulting in burns. There has been some confusion as to whether for remoteness of damage, in addition to being damage of a type which is foreseeable, the damage must occur in a foreseeable manner. In Hughes v. Lord Advocate, two boys took some paraffin lamps down a manhole to explore. Unfortunately, the hole had accumulated some natural gases and an unforeseeable explosion occurred. The defendants were liable as burns were a foreseeable type of damage and it did not matter that the injury was inflicted in an unforeseeable manner. However, in Tremaine v. Pike, the court held the damage must occur in a foreseeable manner when the farm labourer contracted leptospirosis from handling materials on which rats had urinated. At the time it was not known the disease could be caught in that way. In Jebson v. Ministry of Defence, the court appeared to follow Hughes v. Lord Advocate, whereas the case of Jolly v. Sutton suggests the manner of occurrence needs to be foreseeable. A final aspect of remoteness of damage is the eggshell, or thin, skull rule. This means a defendant must take their victim as they find them. That is, if the victim is particularly vulnerable or has a pre-existing condition resulting in them suffering greater injury than would be expected in an ordinary person, the defendant remains responsible for the full extent of the injury. This can be seen in Smith v. Leach Brain, where the claimant suffered a burn to his lip. This happened to be on some precancerous cells. The burn triggered the cancer and the claimant died. The defendant was liable for his death even though such an injury would not generally cause death. A further example is Page v. Smith, where the claimant had previously suffered from ME but was in remission. The minor car accident triggered his ME and the defendant was liable for his psychiatric injury. He was required to pay £162,000 even though such extensive injuries were not a foreseeable consequence of a minor prang. In summary, in tortious claims involving proof of damage, the claimant must establish that the damage was not too remote. Damage will be too remote if it is not of a kind that is a foreseeable consequence of the defendant's act or omission. The courts have been inconsistent with regards to whether the damage must occur in a foreseeable manner. The defendant must take their victim as they find them. This video is part of a series of videos on tort law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.e-lawrevision.org.uk for revision games and quizzes. Thanks for watching.